in cases where the support to the ministry is claimed to have been withdrawn by some legislators, the proper cause for testing the strength of the ministry is holding the test on the floor of the House. Because the Chief Minister said, I am ready to hold that test. And para 3 was there on that day of the 10th schedule. And what did the governor do? 356. It's in that context that Bomai says, which is why I said the other day, these decisions are contextual. There is no general principle that can be applied across the board. There can't be. Freedom of speech is a general principle. How you will actually, recognize it is the context. So first you must reach a bona fide, constitutionally valid conclusion that this requires a floor test and on relevant considerations. If you are able to justify that to the court, then the only remedy is the floor test. The House is the place where the democracy is in action. It is not for the governor to determine the set question on his own or his own verification, which is what exactly he did by recognizing a faction. See, you can't enter into an moment you say, okay, I'll recognize these 3 people, I will entertain these 2 people, and then now you have lost majority, now you have a floor test. Impermissible. That's the old non-10th schedule regime, the Ayagram, Gayaram regime.
Mr. Sibal, the only problem is, I'm just looking at it from this point of view, the basic principle of parliamentary democracy is that a government has to be accountable to and must have the faith of the House. Now, suppose a group of, say, the government has X number of legislators, and take a hypothetical case where X divided by 2, say that we have no faith in this government, though we were elected on their ticket.
Correct.
They say that, look, okay, we incur the disqualification, but we don't have faith in this government. Now, going by your logic, the governor can never call a trust vote because he will say, look, you have been elected as members of the House. You can't say that you have lost faith in which case, even though the government now really effectively has only X by 2 of its confidence in the House, the strength in the House, still the government must continue. The government has to continue. It's basically reduced to a complete minority, probably.
Your Lordship is absolutely right. May I answer that, Malaz? The session is on. Finance bill has to be passed. Vote against it. Government will fall. What's the problem? This is not an insurmountable legal issue. Any vote against it. But what they want is, they want to topple the government, become the chief minister, then tell your lordships, now the speaker will decide. This is not constitutionally permissible. Your lordship is absolutely right. What time does the government lose majority, lose confidence of the House, Mullah? At the time when it is reduced to a minority. At what time does it reduce to a minority? When they vote against the government. It is reduced. That's the solution. Till the time they vote against and the government becomes a minority, it's accountable to the people. The governor cannot assume that they have lost majority, therefore there is no accountability. That's not permissible as far as the governor is concerned. That's respectfully the responsibility to the query that your lordship raised. Prime Minister Nasim Rao ran the minority government. It's not as if governments can't be run by minorities. Point is, they don't want to lose the membership of the House. It's a double whammy, Millers. You lose the membership, you don't become a minister. You have to fight an election. You may win, you may not win. Here, you topple the government to become a minister, you become a chief minister. Use the governor's office for that. Your lordship, Millers, I don't have to say anything more. My political experience and your judicial experience, Millers. We have reduced ourselves to that we are mocked. People don't believe us anymore. We are not against the floor test. We're against the considerations on the basis of which the floor test was ordered. The pendency of proceedings before the Speaker cannot be a valid basis to not have the confidence of the House in the government determined by the convening of a floor test are premised on the constitutional principle that neither the court nor the governor has any right to impinge on the Speaker's power to decide on the issue of disqualification. This court cannot say, that you cannot decide, or I give 10 more days or 10, 15 days. That's not the power. That's not the function of the court. It is straight law that neither the governor nor, for that matter, this court has the power to impinge upon the authority of the speaker to take a decision on the above issues. Well, now 5 judges have said that. Therefore, that order on the 27th put us in a situation, where the elected government was toppled. Neither the governor nor, for that matter, the court can entrench upon the power of the speaker, which is why I pointed out paragraph 6 of the 10th schedule and 180. Because there can't be any hiatus. Speaker's function must continue, and there cannot be any Kitemek order. Nothing prevents the speaker from taking a decision either on matters of resignation or of disqualification despite convening the trust vote. Even in Shivraj Chauhan, your lordship said, because there was no interdiction there. So the court said in Shivraj Chauhan, the speaker could easily disqualify. But in this case, what happened? The speaker could not move. So how does Shivraj Chauhan, an authority for the proposition that a floor test is necessary in these circumstances? The respondents have sought to justify the governor's decision, dated so and so, by relying on Uddhav Thackeray's resignation on 29/6 instead of facing the floor test. Further, it has been contended that even the votes of 42 MLAs were excluded. We are still through. That's not relevant. When Bomai was decided, and Bomai set aside orders under Article 356, what did Bomai say? Bomai said, we have to restore the status quo ante. It doesn't matter what happened thereafter. I'll show those mullahs when I come to that. Bomai said so. Shivraj Chauhan also said so. We're not asking your lordship. That what Bomai said was the acts that have happened in between can be validated by the court. Right? Because there's legislation that is passed, there are other things that have happened. Those acts will be validated in your final decision making. But we cannot say that we can't have the status quo ante. Status quo ante, that's how Arunachal Mullahs was decided, how it was decided. Only on that basis. Status quo ante was restored. It also happened in Uttarakhand Mullahs when this court restored the chief minister Mullahs by setting aside the order of the governor. So we are not saying, Mullahs, that everything that happened thereafter is illegal. No, we are saying that's the molding of the relief as and when your lordships decide one way or the other. So this argument, Mullahs, that is according to an argument of frustration. Because you are now saying, look, subsequent events have happened. I am the chief minister. I am enjoying the fruits of power. Please don't do anything. Now there is confidence in me in the house. All irrelevant. Bomai says so. It further goes on to say that the court may be duty bound to give an interim order of this nature to make effective the constitutional remedy of judicial review and to prevent the emasculation of the constitution. Well, what's the point, Mullahs, of now saying these consequential acts have happened, so you have no judicial remedy, even though the act may be illegal? It is respectfully submitted that governor does not have the power to invite a leader of a faction of a legislative party, acting dehors the political party. But where does the governor get this power from? Who is he recognizing? Leader of what? The governor can only deal with the legislative party. He can't pick out Eknath Shinde and say, now you become the chief minister. It's like saying that the party is registered with the election commission. The leader is as communicated to the election commission, but I, as governor, will pick up another leader contrary to what is communicated to me. The leader continues to be Mullahs. In the instant case, it is undisputed that on the 30th of June, Uddhav Thackeray was the leader of the Shiv Sena political party. However, the governor extended an invitation to form the government of Shinde, whose only claim as on 30th June was that he is the leader of the majority faction of the Shiv Sena legislature party. The governor, as on 30th of June, did not and could not have recognized Mr. Shinde as a leader of the Shiv Sena political party. Our consistent and continuous argument has been that we are within the Shiv Sena, represent the rival faction. Now he's accepting it. Representing the rival faction which ought to be recognized as a political party. Now, this is the cat is out of the bag. Now he's saying outside the constitution, outside the principles of constitutional law, a faction in the legislative party should be recognized as a political party. Without going to the election commission, without registering yourself. What political party? Erroneous conflation of legislature party and political party. I just don't understand on what basis my learned friend made this submission. The whole purpose of the 10th schedule is to talk of the legislative party and the political party as separate entities, and to prevent acts which would amount to disqualification. That's the whole purpose. The Constitution doesn't recognize that. Even the Representation of People Act doesn't recognize the legislature party. It is only in the 10th schedule because you wanted to prevent acts of disqualification. And again, quote from the transcript, we have consistently said so, that a legislature party is integral and originally connected and co-joined to a political party. What's the basis of this submission? And I still say, I am the original political party. So first he says, I am a faction. Now he says, I am the original political party. Because that faction should be recognized by the governor as the original political party. Now they are presuming that this is only a rival faction. He just said that it's a faction within the legislature party and not a rival faction within the political party. Whereas your lordships have time and again said, you can't segregate the two. A legislature party is also an extension of the political party. Our argument right through has been the decision of the legislature party has the authority of the political party. Where does he get that from? Decision of the legislative party has the authority of the political party, unless he says, my faction is the political party. Now come to right to dissent. The respondents have claimed that the 10th schedule cannot be used to stifle dissent within the party, and definitely internal dissent does not amount to voluntarily giving up membership of the party. Well, this whole argument was raised in Kyoto in the context of Article 105 of the Constitution, not in any other context, and was rejected. And 105 of the Constitution, I'll just quickly read it to your lordships. It says, subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of Parliament, there shall be freedom of speech in Parliament. Rejected. Why? Because you are a representative of the political party and bound by the discipline of that party. You have no independent right. Unlike Parliament in England, unlike the Senate and the House, and unlike European Parliament. This is a quotation from Rodney Brazier. Once returned to the House of Commons, members' party expects him to be loyal. This is not entirely unfair or improper, for it is the price of the party's label which secured his election. Now, this loyalty is for a price which has secured him the chief ministership, if I can put it differently. The anti-defection law seeks to recognize the practical need to place the proprieties of political and personal conduct, whose awkward erosion and grotesque manifestation have been the bane of the times. This is recognized by a constitution court. Above certain theoretical assumptions, which in reality have fallen into a morass of personal and political degradation. And this particular litigation is a shining example of that political degradation. Aymal actually mentioned it yesterday. Every act of theirs from the 21st onwards is an act in violation of 21A. Every act of theirs, which is undisputed. 21B, of course, but that's afterwards. E is the decision of the Election Commission in the para 15 cannot efface the disqualification income. But whatever may be the consequence, that disqualification has already happened. Even if the Election Commission's order is right, which is ex facie wrong, but we'll deal with it separately. This disqualification has happened. That cannot efface the disqualification.